Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. As you probably know, Josh Duggar was convicted for possession of bad pictures of children. We're going to avoid certain terms because YouTube hates them. And he was sentenced to 12 years in jail. He then appealed that conviction on the basis that, the real reason he's appealing is that he doesn't want to do 12 years in jail. But the legal arguments he was making was first, that he'd made certain statements to the police, and he said that those statements should have been excluded at trial. And the reason why is he says he was effectively in custody, he wasn't allowed to talk to a lawyer, therefore those statements were taken in violation of his rights. That's his argument. He also says that at trial, he should have been allowed to effectively point the finger at an ex-employee who was a sex offender, and the court had denied him the ability to do that. So he says that that was also an error. Now, that appeal has been thrown out. He was not successful at the appeal. So let's have a look at what goes on in this appeal. We'll talk about why the court does it. We'll go through things in some detail because I think this is it's a worthwhile case to have a look at. So this is the United States Courts of Appeal for the 8th Circuit, United States of America, and Joshua James Duggar. Now, it just starts with a very brief intro paragraph saying, Joshua Duggar challenges his conviction for receiving CP. Although he seeks to suppress incriminating statements and get a new trial, we affirm. So they mean they're affirming the original decision. It's confirmed. The appeal is denied. So now they're going to carry on and explain what's going on. They're going to give us a little bit of background. Duggar used a computer to download hundreds of CP images. And I'll just note here, some of the images that he was downloading are really, really awful ones, even in the sphere of CP images. There was evidence that he was trying to get a particular video that is known as one of the most horrific things that was ever created. In fact, it is so horrific that when investigators who had been dealing with the most horrible stuff you can think of, when they heard of this video, they thought it must be an urban legend or some sort of myth because they thought that there was no way anybody could actually make something that horrible. Unfortunately, it turned out to be real, and there was evidence that Duggar had tried to seek that out and tried to obtain a copy. So, pretty awful stuff. Law enforcement tracked the images to a used car dealership he owned by identifying the IP address of the computer. Not long after, a team of federal agents arrived with a search warrant. Two walked directly up to Duggar, who pulled out a cell phone and said he wanted to call his attorney. That is a great decision. You know, you do want to talk to your attorney if you're being approached by federal agents, no matter what you've done or not done. However, but before he could complete the call, they seized it because it was considered evidence. Now, I'm just going to say, you tell them you want to talk to your lawyer. You wait until you've got some privacy because you don't want to have that lawyer call in front of the officers. And you also don't necessarily want to unlock your phone in front of the officers because then they can just reach out and go, yoink, that's mine. And now they've got your unlocked phone. So Duggar does a bunch of stupid things here, starting with the actual crimes themselves. But lots of people want to know sort of how do I respond to police if they're in my face. So this is kind of a discussion there. When asked whether he would like to discuss further details about the warrant, he said yes. This was not the correct answer. He should have said no. If the police want you to discuss further details about a warrant they have for your stuff, you don't want to talk about it with anyone other than your lawyer. It gets worse. Without waiting for an explanation, Duggar blurted out, "What is this about? Has somebody been downloading CP?" He then let it slip that he was familiar with file sharing software and had installed it on all of his electronic devices, including the computer in the office. So there's a whole lot of really bad stuff here. And, telling them, hey, there's file sharing software on all of the electronic devices. Well, if they were only there to get one electronic device, you know that they're going to now expand that to try to get all of them. But the other thing is this thing about, has somebody been downloading CP? That looks really guilty, right? Because the officers haven't told him what they're there for, and he's saying, oh, it's got to be about CP. So that suggests he knew. Here's the problem with this, is that sometimes people, when faced with police, make a guess. They just try to guess what something is about. And this is a really dangerous thing. This is stupid. You should never do this. When police officers pull you over at the roadside, they might say, "Do you know how fast you were going?" And the correct answer to that is no answer whatsoever. They might, similarly, if they show up at your house with a warrant, say, "Do you know what this is about?" And there is no good answer to that. It's a trick question. And in some ways, they're kind of hoping that you answer it with something new and surprising. Let's say they're there with a warrant because they think you've got stolen property. And you say, "Oh, has somebody been downloading CP?" You better bet that in that case, they're going to go and look at your computers. Or if you say, "Hey, is this about the drugs or the guns or whatever else?" Now they've expanded their investigation. Whereas if you say, "Oh, is this about stolen property?" Now you've basically admitted to the possession of the stolen property. This is an extremely stupid thing he was doing. And why would he do it? Well, because he's trying to deflect. He's trying to talk his way out of things. And quite frankly, it's probably because he's a little guilty here. But yeah. And he was convicted, and that conviction has been affirmed. But yeah, this is just, talking to police is always a bad idea. I'm not super upset that he did, but just what should you do if you're ever dealing with the police? Not a great move. A grand jury indicted Duggar for possessing and receiving CP. Before trial, he filed a motion to suppress the statements he made at the scene without his lawyer present. So he wants those eliminated from the trial. He wanted that at the trial level, and now he's saying at appeal, he's saying he wants those statements eliminated and a new trial where that would be excluded. The district court denied the motion, concluding he was not in custody at the time. Those statements took on a critical role at trial. Of course they're going to take on a critical role. They basically are an admission. And so did the metadata from his phone, which placed it at the dealership when the CP was downloaded. Keep in mind that that's a big deal, right? If he was somewhere else when it was downloaded, then it probably wasn't him. But if he was there at the time, it's much more likely that it was him doing it. Duggar, for his part, tried to point the finger elsewhere. Looking to convince the jury that it faced a classic, old-fashioned whodunit, he suggested that a former employee who happened to be a convicted sex offender was to blame. So he's saying it was that guy. Duggar ultimately decided not to call him to the stand, however, because the district court ruled that any mention of the employee's prior conviction was off limits. You don't get to tell the jury that he's a convicted sex offender. You can just bring this guy up to say maybe it was him, but you can't say why you think it was him. So you have to actually show that it was him because of some opportunity to do it or something like that, rather than just his criminal record. The jury found Duggar guilty as charged. After entering judgment on the receipt of the CP count, the district court sentenced him to 151 months in prison. That's a long time, and it's not going to be easy time. When you're convicted of offenses against children, like this kind of offense, he will be at some risk. There's risks of violence towards him. And because of those risks of violence, he will probably be put into very restrictive custody, where he's not allowed to see a whole lot of people. It's going to be very, very difficult time for him to serve. And I don't have a whole lot of sympathy. Sorry. Duggar believes that the district court's decision to stop him asking about the employee's prior sex offense conviction deprived him of his right to present a complete defense. Our review is de novo. And what de novo means is that they're just doing a review from scratch, as if there was no prior decision. This is the most generous standard of review to Mr. Duggar that is available. It basically says, even though the court ruled against you below, like the lower court, we're not going to hold any of that against you. We're not going to consider that as being even remotely correct. We're just going to start from the beginning. And if we disagree with the lower court, then the lower court's out. So he can't complain that he wasn't given a fair shake when it's a de novo review. So the Fifth and Sixth Amendments guarantee criminal defendants a meaningful opportunity to present a complete defense, which is an important right. What it includes is subject to debate, but there seems to be little doubt that it applies to evidence showing that someone else committed the crime. Obviously, if you've got good evidence to show somebody else committed the crime, you'd have to be able to tender that at trial. Nevertheless, the Supreme Court has struck a balance to accommodate other legitimate interests in the criminal trial process. Ordinary evidentiary rules still apply, except where they infringe upon a weighty interest of the accused and are arbitrary or disproportionate to the purposes they are designed to serve. The district court, for its part, tried to strike a balance too. It recognized that Duggar should have an opportunity to create reasonable doubt, which is actually the wrong way to phrase it. Reasonable doubt is something that the prosecution has to eliminate. The burden is on the prosecution to prove things beyond a reasonable doubt. So it's not that Duggar has to create reasonable doubt, but here he's just trying to show other possibilities. By calling the former employee to testify and asking whether he was present on the car lot when the downloads occurred. But he could not impeach him with a prior sex crime or introduce speculative testimony. And this is looking at the rules of evidence, which explain that a prior felony conviction must be admitted subject to Rule 403 to attack a witness's character for truthfulness. I.e., you could use this to impeach him as to whether or not he was being honest, but you can't just say it's more likely that he committed the offense because he's got this record. You can see why it ends up being a very unfair trial in that circumstance, because this is essentially character evidence, and we don't typically like character evidence because juries might convict just purely on the basis of somebody's past, whether or not there's any evidence that they did it. Now here it's the reverse situation. We're actually trying to use this as a defense that somebody else might have done it. But similarly, just because this guy has a record doesn't mean he's the person who did it. You need to show some other grounds for why that might be possible. So, carrying on, the reason, according to the court, was to prevent confusion. The jury might think he did it because he was a sex offender, even though the conviction was only potentially admissible as impeachment evidence. So, we're keeping this out to avoid misleading the jury. And then that Rule 403 that they mentioned allows courts to exclude relevant evidence if its probative value is substantially outweighed by a danger of confusing the issues. Probative value here means that it's value towards the truth-seeking function, towards determining the correct guilt or innocence of somebody. But if that's outweighed by messing with trial in various other ways, then it can still be excluded. And that's why they ruled it out here. They also mention that the similarity of the past crime is a factor militating against admission because the likelihood a juror might impermissibly use the conduct to suggest guilt rather than merely incredibility. And so let's consider different possibilities. If you're pointing to somebody, you've got a witness, and they have a prior conviction for perjury. Perjury might be really relevant to whether or not you believe this witness on the stand. Is this an honest witness? Well, they've lied in court before, under oath. That's what perjury means. But let's say you're talking about a car theft, and this prior person has a lengthy history of car thefts. Car thefts might not necessarily indicate a willingness to lie on the stand, but you can really see how a jury would say, oh, it might be that car thief. But you could just find any nearby car thief. It becomes a very weird and unfair trial system if that's all you need to do. The court had no obligation under the Fifth and Sixth Amendments to do anything more. As the Supreme Court has put it, nothing in the Constitution calls into question well-established rules that permit trial judges to exclude evidence if its probative value is outweighed by certain other factors, such as unfair prejudice, confusion of the issues, or potential to mislead the jury. And that last one is the big issue here. The right to present a complete defense, in other words, does not trump a district court's discretion to keep out confusing or misleading evidence even if it would be helpful to the defense. And they mentioned Crane and Kennedy, which emphasized that courts have wide latitude to exclude evidence that is repetitive, only marginally relevant, or poses an undue risk of harassment, prejudice, or confusion of the issues. So Duggar had the option, he had the opportunity of trying to indicate that this other guy had opportunity. Were you there at the car lot at the same time these images were downloaded? Did you have access to these computers? These kinds of things would have been permitted questions. They could even have suggested to him that he did it. All of these were possible things that they could do. What they can't do is just kind of point to his existence and say, he's there and he's a sex offender, so it's got to be him. Yeah. They need something. They need to actually establish that he's a possibility there. And they couldn't do it. That's why they didn't want to call him. The only thing that it looks like they wanted to call him for was just to point and say, hey, there was a sex offender nearby. Maybe him. So, in short, the district court had unquestionably constitutional discretion to exclude the conviction under Federal Rules of Evidence 403. It necessarily follows that the court's application of this well-established rule could not have violated Duggar's Fifth and Sixth Amendment rights. And they cite Holmes, concluding that the exclusion of alternative perpetrator evidence under Minnesota's version of Rule 403 did not violate the defendant's right to present a complete defense. So they're saying past case law exactly on this point had said that this is not a problem. It is true, as Duggar points out, that the district court slipped up along the way. They made a mistake. Now, here's the thing. Not every mistake that the court makes is going to mean that you get a successful appeal. It mentioned the strength of the prosecution's case as a factor weighing against the admission of alternative perpetrator evidence. And that's the reason why that's a mistake, is that's not a factor. And in fact, if there's really strong prosecution's case, that might in fact be all the more reason to allow for pointing to an alternative perpetrator, because they might say, we've got a really strong case against you, but you can point to and say, it's actually an even better case against that other guy. That other guy's the real person. So, although this statement was wrong, any error was harmless. And harmless errors, the court's not going to correct. They're only going to correct an error of the lower court if it was meaningful, if it actually would have changed the verdict. The district court later clarified that it actually relied on the weaknesses in Duggar's evidence and the risk of confusion, not the strength of the government's case. So they made a clarification and say, yeah, we misspoke. And that's fine. They're allowed to sort of correct themselves. C. Holmes, emphasizing the need to focus on the probative value or the potential adverse effects of admitting the defense evidence of third-party guilt. And United States and White Plume, affirming a ruling that limited the defendant's ability to impeach his wife with evidence that she had previously abused children when he provided only speculation to connect it to later abuse. You've got to have something to actually connect it. And the court might have allowed this evidence if there was something more than pure speculation that it was this guy. If there was something like, at the time of these offenses, the login on this computer was it was logged in under this employee, for instance. That might have been something other than pure speculation to allow for them to get to that point. But you can't just sort of point at that guy and say, maybe it's him, with nothing else. Both were independently valid reasons for limiting the alternative perpetrator evidence that Duggar could introduce. In his second argument, Duggar shifts his attention from what the district court kept out to what it let in. You know that when the court is using turns of phrase like this, things are not going well. I mean, they told us that they're not going well for Duggar right at the outset, because of course, right at the outset, they tell us that they're affirming the verdict. But yeah, this is very gentle shade. His incriminating statements during the search at the car dealership. He wanted them suppressed on the ground that agents violated his right to counsel, which he tried to evoke by mentioning a lawyer and then attempting to call one. And that's a pretty clear invocation of right to counsel. I want to talk to a lawyer, and look at me on the phone trying to phone the lawyer, it's clear that you are trying to contact a lawyer. We review any factual findings for clear error. So factual findings, appeals courts don't normally rehear the facts. And the reason for that is that the trial court actually got to see the witnesses and see all of this stuff. And so they're in the best position to make factual determinations. So what they're saying is that if he's got an issue with the actual facts as were found by the lower court, he has to show that they were clearly wrong. However, they're going to consider de novo whether Duggar's right to counsel had attached, whether he actually had a right to speak to a lawyer at that particular time. That part is going to be considered on the very generous de novo standard. The right to counsel at issue relates to the Fifth Amendment guarantee against self-incrimination. No person shall be compelled in any criminal case to be a witness against himself. Under Miranda, such protections attach, including a right to counsel, the moment a suspect is in custody. Now, in custody gets to be a fuzzy term, as they'll talk about, and I'll explain a little further. So you see United States v. Ferguson stating that whether a person is in custody dictates whether he's entitled to Miranda protections. So for example, if a police officer phones you and you're sitting on your couch and you say, I want to talk to a lawyer, you don't yet have a right to talk to a lawyer at that point. The officer doesn't necessarily have to hang up the phone. It's just you would have to hang up the phone yourself and do that. The reason why you have this right to talk to a lawyer once you're in custody is because when you're in custody, your movements are now under their control. So for example, if you're not in custody and they're just searching your car dealership, then you can go and talk to a lawyer if you want. You don't need the right to, other than just your right to move around. He had the option to go and leave and like find a payphone or, wherever, and like walk home, call from his home phone if he's got a home phone. All of those things were options to him. He could just leave. He doesn't have to provide a statement. But when your movements are under control and you don't have the ability to leave, then they're required to uphold those rights. That's sort of why that distinction is there. Here, the government argues that even if the agents interrogated Duggar, they did not take him into custody before he incriminated himself. Interesting points here. Custody includes more than just formal arrest. So you're definitely in custody if the officers say you are under arrest, they start reading you your rights, they put you in handcuffs, they put you in a locked cruiser, or they put you in a cell. That's definitely custody, right? But there's other circumstances that might be custody even though you're not under formal arrest. Let's say the officer says you're not under arrest, but he still got you in handcuffs in the back of a locked cruiser. You're still in custody, right? Even though he's saying you're not under arrest, you're like, but I can't leave. If there were 10 cops standing around you, forming a circle of big burly guys, and they're not letting you out, that seems like custody. There's all of these circumstances. This ends up getting weighed, and the court has to consider it because, as the court here will say, it also covers situations in which a reasonable person in the suspect's shoes would consider his freedom of movement restricted to the degree associated with formal arrest. And this might be very simple. It might be, for instance, an officer tells you to go sit in the corner in a chair. And you say, hey, can I go to the bathroom? And the officer says, no, you stay in the chair. The officer says, oh, he could technically have left at any point. We hadn't arrested him. If they're telling you to sit in a specific place and they're denying you the ability to get up and go to the bathroom, then you would feel that your movement is restricted in that fashion. So everyone agrees that there was no arrest that day, but we must still consider if someone in Duggar's shoes might have reasonably thought otherwise. 6 factors guide our analysis, so they're going to go through them, and we're going to go through them. 1, whether the suspect was informed at the time of questioning that the questioning was voluntary, that the suspect was free to leave, or request the officers to do so. Like if you can kick the officers out of your house, then you're probably not in custody in your house. Or that the suspect was not considered under arrest. So, did the officers tell you these things? That matters, because if they didn't, then you might conclude that you didn't have those powers. Whether the suspect possessed unrestrained freedom of movement during questioning. Were you boxed in by officers blocking you? Was somebody grabbing onto your arm and preventing you from moving? These kinds of things. Whether the suspect initiated contact with authorities or voluntarily acquiesced to official requests to respond to questions. So let's say there's an officer who's investigating a break-in on your street. And, he sees you walking down, you're walking on the other side of the street, and he goes, "Hey, would you come here for a second? I've got some questions." And you say, "Yeah, sure," and you walk over. You're less likely to be found to be under arrest. Whereas if the officer runs up to you and, gets right in your face and starts asking you questions, more likely. Whether strong-arm tactics or deceptive stratagems were employed during questioning. Did they lean in and were they really intimidating, big, that kind of thing? Did they trick you? Those matter. Whether the atmosphere of questioning was police-dominated. Or, 6, whether the suspect was placed under arrest at the termination of the questioning. If as soon as the police are done, they throw handcuffs on you, it's probably more likely that they wouldn't have let you leave earlier in the questioning. That's kind of what that gets at. The first factor, which is the most obvious and effective means of demonstrating that a suspect has not been taken into custody, weighs heavily in the government's favor. And the most obvious is because if they tell you that you are free to go, then why wouldn't you think that you're free to go? Now that can change. Like if they tell you you're free to go, but they're grabbing onto your arm the whole time, maybe you would not believe that. Similarly, if they told you that you're free to leave, but when you try to leave, they're like, "Where are you going?" And they block your way. Maybe this factor would be overborne. When the agents arrived, they told Duggar that they had a federal search warrant, not an arrest warrant, and that he was free to leave if he chose to do so. Later, when the agents invited Duggar to speak with them, they reiterated that he had the right to stop the questioning at any time. The agents, in other words, clearly informed Duggar that he was free to leave or to decline questioning. So they told him he was free to go. And if the officers tell you that you're free to leave or to decline questioning, you should decline questioning and leave. I mean, talk to your lawyer, but as general principles as opposed to, but get specific advice for your situation. And if they're not letting you call your lawyer while you're with them, but they are letting you leave, you can leave and call your lawyer. Maybe your lawyer says, "Get back there." I doubt it, but maybe. It is true that the agents read him his Miranda rights, which ordinarily might leave someone with the impression they are in custody. But when Duggar signed a form acknowledging his rights, he had the agents scratch out the portion saying that he was being taken into custody. Modifying the form made it clear he was free to leave. So I read this and I'm going, is this the case? Like he had the agents scratch that portion out and say, So if he did that, then clearly he understood he wasn't being taken into custody. Even if the officers did that on their own, then that suggests that. But yeah, you can see right here, it's scratched out. I was taken into custody at time. He says, "No, I wasn't." Scratch that out. That his lawyers really didn't like that on appeal, even though he thought he was being helpful. The second and third factors also favor the government. Also, if they're ever trying to get you to sign something to acknowledge that you understand your rights, it's because you're about to get screwed. That's why they're doing that. The second and third factors also favor the government. Not going great for Duggar so far. Duggar sat in the front passenger seat of the agent's truck during the interview, so not in the locked rear portion. They did not handcuff him. The doors remained unlocked, and he entered and exited the front seat of the vehicle on his own, which means that he retained freedom of movement throughout the encounter. And although the agents initiated contact with Duggar, he still voluntarily acquiesced to the questioning. He said, yeah, sure, I'll answer questions. Indeed, he began the interview with a question of his own. Has somebody been downloading CP? Which was a terrible question. It was a very stupid question. And continued to converse with them for about an hour. The fourth and fifth factors, by contrast, do not move the needle much in either direction, which also doesn't help Duggar here because he's already in the hole on this one. So he really needed to move the needle, and if they're not moving the needle, that's not in his favor. It is true that the agents failed to follow through on their promise to alert Duggar's lawyer to the search. Even so, it would not have prevented a reasonable person from terminating the interview. Hey, I haven't talked to my lawyer yet. I'm going to leave. Or just, I'm going to leave regardless. See United States v. Loretta, which explained that the use of deception is irrelevant unless it relates to a reasonable person's perception of his freedom to depart. And it doesn't look like the court here found that this was deceptive so much as just that they never actually got around to it. Nor does the fact that law enforcement assumed control of the dealership necessarily mean that the interview was police dominated. Because he could have left the dealership at any point. At least not here when Duggar and the agents were engaged in consensual two-way questioning. The very fact that he's asked questions of the officers is being held against him here. Anything you say and the means, the matter, the way you say it can be held against you. There is no way to win by talking to the cops, and Duggar lost every way. And you might not have sympathy for Duggar. I don't think he's sympathetic. I don't have sympathy for him. But if you are ever in this situation and you haven't done anything, keep in mind there is nothing good to be gained from talking to the cops. C. Johnson describing the fifth factor as mixed when the interviews were two-way discussions but occurred in the agent's vehicle. Finally, Duggar was not arrested at the termination of the questioning. To the contrary, he ended the interview on his own and then left the dealership. Hardly an option available to someone in custody. You know, that's the thing. This is the fundamental question about whether or not you're in custody is, can you end the interview and leave? And when he was done talking, done burying himself, but done talking, he ended the interview and left. That pretty much shows that he wasn't in custody here. Viewed through Griffin's lens, we conclude that a reasonable person in Duggar's position would not have thought his freedom of movement was restricted. It follows that the admission of his statements did not violate Miranda. The last issue deals with the metadata from Duggar's iPhone. And metadata is data about data. So when you take a picture on your phone, the picture itself is the data, like the base data. But your phone also stores a whole bunch of things about that picture. What time was it taken? What was the shutter speed? What was the, what were all the settings? What was your GPS location, if that's enabled? All sorts of things. And your phone stores so much information. And what I mean by that is that if I just take this phone and I turn it, it stores that as an event. That is now recorded on my phone that I turned the phone. So your phone is an absolute treasure trove of information about you. It is basically, they couldn't get as much information about you by hiring a spy to follow you and surveil you as they can from just getting your phone. It's huge. So, yeah. So they define metadata as data that describes other data, including the origin, structure, or characteristics of computer files. Here, according to the government's forensic analyst, it revealed that where, at the dealership, and the when, at the same time as the CP downloads, that connected Duggar to the crime, which is pretty critical evidence, right? Because if it's just, it was downloaded and we don't even know if he was there at the time, that's weak evidence, but it was downloaded and he was totally right there is much stronger. On appeal, he challenges the analyst's qualifications and methods as well as the limitations placed on the testimony of his own expert. Our review of both issues is for an abuse of discretion, which is not a favorable standard for Duggar. He's got a bit of a hill to climb to make out these issues. The government's analyst explained in detail how he conducted his analysis. His examination began with photographs that Duggar had transferred from his iPhone to his laptop. They contained a lot of EXIF information, which is metadata, including the GPS coordinates of where he took them. So, see Hager, which explains that EXIF metadata provides identifying information about a file, like when the file was produced, when it was last modified. The next step involved plotting the coordinates online in programs like Bing and Google Maps, which placed the iPhone at the car lot at the same time as the downloads of the CP. So they've got the map coordinates, like they've got the GPS coordinates. And then the next step is just to basically say, we know what this place is. What else is at that place, by looking at the map and going, oh, it's at the car dealership where the downloads happened. That's a bad thing. The analyst was qualified to testify about what he found. To start, not everything he said required scientific, technical, or other specialized knowledge. For example, even if interpreting EXIF metadata takes some expertise, and I'm not even sure that this is a matter that is necessarily within the sphere of expertise at this stage, because I am not a tech expert by any stretch, but I could certainly look at phone metadata and plot it onto a map, like from an image. If it was not stripped out, that's not a hard task. So, and then they cite another court case noting that the process of plotting coordinates on a map does not require expert evidence. Nor did the analyst have an obligation to explain how GPS technology works, given that its accuracy and reliability are not subject to reasonable dispute. They didn't need an expert on GPS working. That's getting some debate, and I'll explain why I go about that. To the extent some of the testimony required specialized knowledge, the district court did not abuse its discretion in concluding that he had it. After all, he'd examined thousands of electronic devices and written hundreds of forensic reports, many of which involved the analysis of EXIF metadata. And they cite United States versus Perry, which affirmed the admission of expert testimony by a firearm examiner with 8 years of experience who had previously performed ballistic comparisons a few dozen times. Now, I'm just going to say, the firearm comparison is not a good comparison. It's not a favorable comparison, because we've just had, I think it was Maryland that issued a scathing rebuke of ballistic comparisons. And I've got a challenge that is open to firearm examiners. I'm still finalizing the rules, but I'm going to get that together. I've put up 500. I think Andrew Bronca matched that with 500. We might turn this into a fundraiser to see if we can take this to officers and be like, hey, let's do it. But I don't think that they're actually as good as they think they are at these ballistic comparisons. The analyst also provided enough detail to conclude that his methods were reliably applied. First, he personally examined the photographs himself. And so they're citing rules of evidence, allowing an expert to base an opinion on facts or data that he personally observed. Then he looked at the raw data and verified that it's basically accurate by displaying the GPS coordinates in online maps. Given that he'd used these methods in many cases over a long time and that he double-checked his work before reaching a conclusion, we cannot say the court abused its discretion in admitting his testimony. And abused discretion, again, is a high standard. It's not just that they would have gone a different direction. If the court would have gone a different direction here, they're still going to affirm the lower court. Abused discretion basically means that they had to have... it had to have been a clear mistake. I'm trying to sort of phrase these in layman's terms, and it's a little hard because they're sort of defined in legal jargon. The same goes for the limitations on what Duggar's expert could say. Duggar's expert, in fact, This is actually really bad for the expert. Let's go and have a look at what this expert does, and it's really bad. The same goes for the limitation on what Duggar's experts could say. Although the district court allowed her to speak generally about EXIF metadata, she could not suggest that the dates and times were wrong. She never loaded any of it into her software. So as she put it, her testimony consisted of a lot of, I don't knows. What you want from an expert is not a lot of, I don't know. You want a lot of, this is the thing, and it supports our case. It was not an abuse of discretion to limit her testimony to what she knew. I mean, how could it be? After all, it would have been pure conjecture for her to suggest that there were errors in metadata she never examined. How can you say it's wrong if you never looked at it? Not to mention, it had the potential to confuse and mislead the jury. No kidding. I'm guessing that was the point. It does not matter that the government cross-examined her about the EXIF timestamps on the photographs. She responded by assuming the information in the government's exhibits was accurate because she had not personally verified it. Given that qualification, she did not leave the jury with the false impression that she agreed with the government's analysis. There was, in other words, nothing for her to clarify. She was an expert who did no actual independent checking, and therefore, when you do no independent checking and all you can do is assume that the government's data is accurate, but maybe like try to throw some smoke and mirrors up, the court was like, you don't get to do this. You don't get to play games where you're pretending that this could be wrong based on nothing. If you want to say that it's wrong, actually look at the data. Tell us that it's wrong, how it's wrong, and so forth. Don't just throw smoke. That seems reasonable to me. So Duggar's appeal has been rejected. He is he's still in custody, still going to get to do his 12 years. And as I said, no sympathy for the guy, because when I hear that somebody was trying to track down that one particular video file, even if he never succeeded at it, that's the sort of thing that I'm just like, ooh, you have dropped off the sympathy food chain entirely. So yeah, some people wanted me to go through that appeal and have a look at it. So we've done so in a 40-minute video, which means that this one will be unpopular, but all the same, sometimes we got to do the deep dives. Anyway, please like this video, share it with your friends, subscribe to see more content. I also want to thank my Patreon supporters at the $50 level: CCFR, CAIM, Canada's National Firearms Association, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited and Jane Babe and Luxor. And at the $20 level, Lindsay Metcalf, Larry Kalniak, Here's a Coin, Legal Witcher, Cameron Johnson, Andrew Elsich, Vicky, and Dorky Dane. Thank you as well to my $10 supporters who will be in the crawl immediately following. Thank you for watching. Hope this has armed you with knowledge. See you next time.